Okay, let's kick things off for today's webinar, the problem dealing with related parties. Now, interesting subject matter. I've been studying closely a lot of cases recently, and for those that sort of follow along with what I do, you know that a lot of commentary around various estate planning cases and other things, but there's been a real uptick in cases that are dealing with related party transactions, which suggests to me that it's still an area of some concern from an industry point of view. But even more remarkable, in my opinion, is that a number of the cases that I'm going to run through with you today as part of, a part of the overview of some of the key issues, they're actually linked to what people would potentially describe as, not necessarily in every instance SMSF industry participants, but certainly with reference to professionals, accountants, tax agents, auditors, others as well, dealing in the SMSF space. So we're not immune to making errors ourselves in this space. So we just need to make sure that we understand the rules as we go along. So let's dive into it. Of course, from a disclaimer point of view, it's one of those things, isn't it, where I talk about contributions and that a lot, and my disclaimer is pretty relevant because you have to move with the times. The related party transactions and a lot of the superannuation investment restrictions, they don't change too often. We to be fair, we've probably the last significant change was the introduction around things such as the market valuations and investment strategy requirements back in sort of 2012, 2013. Of course, we've had a lot of interpretive change with reference to things like limited recourse borrowing arrangements, but they themselves were brought in 07 and then tied it up in 2010. So, we've really had, and probably then the last one was our collectible and personal use assets. So realistically, we don't see a lot of change, but we do see a lot of movement in this space, primarily because the ATO are reacting to other things that occur within the industry, and they then subsequently have a flow-on effect with regards to a lot of our related party transactions. And of course, the most relevant one of current times, which I will touch on in today's session, is of course the non-arm's length income, and we saw that legislation pass at the end of June. Of course, for specific investments, the legislation's been in place since 2018, so it's not really a new thing. But now that we've got certainty around the legislation, what it seems to suggest to me is we'll start to see some more certainty from the regulator, potentially with a refresh of LCR 2021-2, which is the ruling about SMSF expenses. But for me, more importantly, is hopefully a finalisation of tax ruling 2010-1. What is a contribution, and when is a contribution deductible? To me, is still a pretty critical ruling, and the key piece of that, linked back to the non-arm's length expenditure, is the whole acquisition of assets from related parties and the link between the acquisition and the use of in-specie contributions, and that is certainly right up the avenue of what we're touching on in today's webinar. So, fingers crossed we get a resolution on that ruling sort of sooner rather than later. We just had the ruling released for when a pension commences and ceases, so they're tidying up a few of these old school type documents that they're onto in the tax office. So hopefully we'll get the contribution one sorted. So look, largely what we'll touch on today is I'm going to run through those the various investment restrictions, of course, starting with the sole purpose test. But I don't want to spend too much time sort of focusing on the nuances of that test as such. Similarly, I don't want to spend too much time focusing on who and who isn't a related party. I want to touch more on the key issues associated with it. I really want to sort of drill deeper into the couple of cases that I want to touch on with regards to the webinar, as to some of the critical thinkings and things that we need to watch out for in this space when we're advising clients. So realistically, I'll run through the vast majority of the investment restrictions, not really touching on collectible and personal use assets today. and then we'll finish with related party case law. So those cases that for me are quite relevant and quite interesting with regards to what people try to do and what they ultimately don't necessarily get away with, and the ramifications in each of those sets of circumstances. So let's have a little look at why this whole related party transaction is a key one for me. And the real consideration for me, the real issue is that all of those red contraventions are linked to related party transactions. Now, arguably, the other issues, the administrative issues associated with SMSF contraventions, operating standards, and whatever they classify as other, you could probably argue they're also related party transactions, given that the scope of SMSF trustees and members being the same. You'd have to think that in most instances those links are across the board. But I think the key thing about those numbers is that when you look at them from a percentage point of view, member loans 20%. So that's financial assistance. It's not directly the provision of a loan. So it's not always about providing loan documents, and it's often rarely about providing loan documents. It's more about using the resources of the fund to provide some form of financial assistance, some form of financial accommodation to the members or their relatives. It's been the number one breach from a percentage point of view forever, basically. There's not a year that these numbers haven't come out where member loans hasn't been number one. Of course, from a valuation point of view, the in-house assets is always the larger percentage breach. And I think largely that's because what happens with in-house assets is, because we're restricted to 5%, normally if somebody breaches the in-house asset rules, it's generally of two consequences. One, it's a consequence of them exceeding the 5%, because the value of the in-house asset itself has risen, and that can often result in the investment jumping above that 5, so being quite representative of the overall fund investments. But secondly is where you've got that existing in-house asset exception, which is our 1322C investments, and they regularly provide for a significant value of the fund. So any fund that holds an investment via a 1322C unit trust, normally that investment, again, let's call it what it is, generally property, makes up a fair proportion of the fund. So when you breach the 1322D regulations, then that's going to have a significant impact on the valuation of any breach from an in-house asset point of view. So what's interesting again is when we talk about a couple of the cases today, and when we go back and look over the years at the various cases that have been released in this space, a lot of them do hinge on the conversation around whether or not an investment is an investment in an in-house asset, and as such, it becomes a pretty critical sort of understanding piece with reference to this whole related party transaction. And when I summarize today's webinar, I'm going to do so with effectively 3 questions, and there might be more there, but 3 primary questions that I always try to ask clients who ask me questions about whether an investment is possible or not. Where you go through the whole concept of whether it's appropriate from an investment strategy point of view, et cetera, but then to determine whether or not it satisfies the investment restrictions. There's certain questions, and to me, it's important the order in which you ask those questions to determine how much further, as SMSF professionals, we have to look into these things. And for me, this is a consistent message that I've given since I started talking about these investment restrictions, and that in itself as a subject matter is probably coming up to its 20-year anniversary with reference from a presentation point of view. But of course, overriding all of that is the sole purpose test, and of course, again, without continually just jumping back to this, the sole purpose test from a valuation point of view, it doesn't represent a significant value. It doesn't represent a significant number. It comes in there as the 4th or the 5th primary breach from a fund point of view. But arguably, you would suggest that it ultimately covers off on the vast majority of contraventions. It's just whether or not an auditor is making a decision whether it's appropriate to breach under Section 62 or not. And what it really comes down to for me is that, you know, when we're talking to our clients about why they're making any decision about the fund, they just have to line that decision up with the sole purpose test. So they ultimately need to say, okay, well, for this fund to be a compliant fund, we have to satisfy Section 62, and to satisfy Section 62, we have to have our fund in existence for one of the core purposes. We can have it in existence for an ancillary purpose, as long as we still have the overriding objective of the fund to be for the core purpose. So when we walk through these purposes, we've got the primary three. Right now, I actually really reference it generally as the primary two, so retirement and reaching age 65. And then the third sort of branch of the core purposes from an SMSF point of view is the death benefit side. And it's always important to understand that, you know, that the provision of benefits for a member when they retire, right? There's your first one, because you often will retire, or many people will retire before 65. Secondly, if we don't retire before 65, then our objective is to reach a particular age, and that age is currently 65. So once we've satisfied those conditions, then we can start the payment of a benefit. We then have the third branch, as I said, which is the death benefit. And of course, from a core purpose point of view, the whole relevance here is if you happen to pass away before you retire or before you reach 65, then that is a core purpose, right, to provide benefits to the member's beneficiaries. So it's one of those sorts of key things, and this sort of aligns with itself with the concept, the ultimate concept that we often get a little bit hung up on, which is that superannuation is not an estate planning vehicle, right? So the broader, more expansive reference to that is that superannuation is not an estate planning vehicle other than as an ancillary purpose. So it's ancillary to the provision of benefits when you retire or attain age 65. But if you don't make that, it's core purpose to pay out a death benefit beforehand. Once you have retired or once you have reached 65, then in addition to paying yourself a benefit, the fund has the capacity to pay out a death benefit to beneficiaries following retirement and following attaining age 65. But that fits under that ancillary purpose. So as I said, to be ancillary, you have to have met one of the core purposes first. So this is when you start to talk about ill health, permanent incapacity, temporary incapacity, death benefits after retirement, a few of the other conditions. Now, termination of employment one is an interesting one because it's really a restrictive condition of release. It's restrictive even as an ancillary purpose. And one of the cases that I will reference again today tried to ultimately access their super benefits under that termination of employment arrangement. And they ultimately, you know, they might say it differently, but they ultimately concocted a scheme, given that it was related parties involved in the transaction, to try to access their benefits under that termination of employment condition of release. And then this is where related parties can fall foul of the law when the objective versus the stated objective of the fund don't necessarily align. So we've got to have that link to our core purpose, and then knowing that with that in mind, we do have the ability to pay out under those ancillary purposes as well. Of course, the good thing is you don't have to state which purpose the fund is operating for. You just have to have it from a membership point of view and a trusteeship point of view. Say, okay, well, here's what we're doing. Our objective is to pay benefits for ourselves in retirement, and then, you know, we need to drill deeper, which is where this SMSF rule in 2008 comes in, where the tax office have ultimately said, okay, well, this is really how we interpret the sole purpose test. That firstly, everything is objective, so you must take an objective view of transactions. So they're only interested in the facts, right? Now, of course, the facts are always going to be interpreted differently, you know, and to me, one of the key issues you've got to understand is that the motivation behind any transaction will often become apparent just in the way that trustees communicate it with yourselves, to the regulator, to other parties. And so, you know, what is the ultimate motivation behind any transaction that the fund is doing? If we're saying we want to acquire this investment, right? Because we see the potential for great return, and that great return is going to help us enhance our retirement income benefits, like what we can actually draw down when we get to retirement. Then bang, satisfaction of the sole purpose test, to me, without a shadow of a doubt. However, the one that I get asked a lot of times, and a little bit concerned at the minute, I don't know about you all, and there's a good number of you on the webinar today, but I don't know how many of you sort of scour through various social media applications, programs, or whatever. I'm staggered with the number of advertisements I'm seeing at the moment that says, have you got X amount in your super? Would you like to buy a property? Now, it's dangerous advertising for one. If you read some of the fine print, so I often click on these links. I don't give out any of my information to follow through on them, but I often click on some of these links just to see what they're talking about. And you then go through and read the comments. Now, the comments are what are the scariest part of these transactions, because a lot of people will say, you can't buy property in super and live in that property. Tick. Some people are reading things to a certain degree, and then they say until you retire, right? And that to me is really dangerous commentary, right? Because the reality is you can't do that. You cannot invest in property, right? The objective of the transaction can't be to buy property to move into when you retire, right? Because that's not necessarily meeting the core purpose of to draw down an income stream, right? Or whatever it might be, draw a lump sum when you hit retirement. Now, let's turn that a different way. If the fund invests in residential property and says that we're going to invest in residential property because we see this property as having great potential for capital appreciation, well, that's helping us out from a point of view of having larger balances. We also see that it might be able to generate reasonable rental income, which will then assist in the liquidity to pay out an income stream once we hit retirement age. And so therefore, we're starting to head down the right path as to why a particular investment would satisfy the sole purpose test. Now, if you get to retirement and you make a decision, right, because you no longer want to have self-managed super fund or whatever, or the investments no longer suit the fund's needs, and you pay out a benefit payment and subsequently move into that property, well, then ultimately what the tax office are going to want to know is, what was your intention from the start, right? And so it depends on how you document all of these issues. Now, I mean, if we're talking about an investment that the fund has held for a significant period of time and it has generated good return, it has generated good growth, well, it's going to be very hard for the tax office to argue. And you've got an investment strategy that identifies that the fund wishes or wanted to invest in property for various reasons. It's very difficult for the ATO to argue it's a breach of the sole purpose test. But the number of times I've done a presentation to trustees, and the trustees say, can we buy a property now and live in it later? Well, their purpose has already been outlined. And I think it's incumbent on everybody to recognize that when people are asking those sorts of questions and say, no, you cannot do it. Right? And so they're looking at if there is any benefit associated with any investment, that it's inherent or unavoidable in the activities. And so it's remote or isolated or insignificant. So there might be a benefit attached to things, but it wasn't what you sought out. So when you're looking at various transactions, you're saying, well, why did we enter this transaction? Well, we entered this transaction, right? We did our limited recourse borrowing arrangement with this lender because they then gave us this cheap insurance outside of super. They then gave us these other benefits associated with having that loan. It's like, well, if you did it because of the other benefits that it provided to you, right, then arguably that wasn't insignificant in the decision making and could arguably be a breach of the sole purpose test. So it's really a big watch this space, particularly when we're dealing with related party transactions, and particularly when we're dealing with, as I'll come across soon, acquiring assets from a related party. So when we're acquiring an asset from a related party, the question really has to be, why? Why are we doing it? Right? What is the benefit of acquiring that particular asset from the related party, as opposed to acquiring that asset from somebody unrelated to the superannuation fund? Right? And you'd have to be very clear in what the motivation for doing so is. right? And what the actual purpose of understanding or undertaking that transaction will be. And again, going to reference a case, a recent case, which has been going on for a couple of years now, which highlights that the law provides certain situations, but in doing or undertaking transactions, even though the law provides for it, it can be a breach of the sole purpose test. So all these factors that we need to take into consideration. So having that at the back of our mind is pretty critical. And then the other thing that's always critical in this concept is who the parties are that we're dealing with. So as I said, at the end of the session, I'm going to summarize the key considerations. And for me, the key considerations of any transaction that an SMSF enters into, the first transaction that we have to, or the first question we have to always ask is, who are we dealing with? Right? So if we're acquiring an asset, if we're investing in something, who are we acquiring it from? What are we investing in? Right? If we're acquiring it from a related party, right? Who is that? Or if it's a party that we have some form of relationship with, are they a related party? Do we know who they are and what that link is? Because under the acquisition of an asset from a related party rules, it says that the trustees or the investment manager, let's be honest, for self-managed super funds, it's all about the trustees. The trustees must not intentionally acquire an asset from a related party. Very hard to argue when you are both the trustee and the related party. Very difficult to argue that you didn't intentionally acquire an asset from a related party. Right? There may be some transactions where the link isn't clear, but I would argue that they're very few and far between, given that the majority of related party acquisition is the member acquiring assets from their immediate family or their immediate family entities, such as a trust or a company. So we do need to understand the concept of who a related party is, because it ultimately drives all of the decisions that we need to make. And these slides for me are slides that I've spoken through many times and always reference back and always go back to them to say that some parts of this definition are pretty simple and other parts of this definition are a little bit more complex. And we have to make sure that we, one, focus on the simple so that we don't make easy mistakes or silly mistakes in this regard, but really drill down to ensure that the complex nature of related party definition is not something that's going to get us caught up. So a related party, and we're looking at this generally as the individuals of the fund. So as a member of the fund, will include other fund members, right? So that straight away takes us down a path to say, okay, who should we be in a self-managed super fund with? Right? Now we know we can have up to 6 people in the fund. Who should we be in a fund with? Right? Immediate family is the obvious answer to that, because immediate family, as we drill down into the definition, is always going to be a related party of the fund, subject, of course, to things like separation or whatever, but largely we're talking about those individuals as always being related parties. We then look and say, okay, well, immediate family are good people to be members of funds. What about business associates? Well, if you're not related to that business associate, then having them in the same fund as you creates a bigger pool of parties that are going to be related to you. So there has to be some pretty valid reasons to have non-related parties or non-relative members within the one superannuation fund. And often that'll be from a business structure point of view. But the counter argument to that is, well, why don't we have them in separate superannuation funds with separate trustee structures so they're in no way influencing the decisions of the fund? And that's, one of the critical decisions that needs to be discussed when contemplating who should be in fund with other parties. And of course, things like then, friends, what can I say? I would say that is not a great decision from a trustee point of view to be in a fund with friends or unrelated associates that you're not in business with as well. So there's a whole myriad of people that you shouldn't be in funds with. Arguably, there's a lot of people out there who will say that there's certain family members you shouldn't be in a fund with as well. And that's a debate for another day, but it's one of the key issues, particularly with regards to related party transactions. We've then got the expansion to include a standard employer sponsor of the fund. Again, this is largely irrelevant in the SMSF space these days. Interestingly, one of the cases that I'm going to discuss, their current trust deed is dated 1994, which to me is slightly problematic anyhow, But the other side of that is, well, if it's a 1994 deed, then it's a pre-self-managed super fund definition deed, which means it could actually be an employer sponsor fund, right? And subject to the way that the deed's written, it could actually be a standard employer sponsor. So a standard employer sponsor is a fund where the trustees will often act on instruction from the employer, right? And so any entitlements and things like that are based on employer-based decisions. So everybody who receives super guarantee has an employer sponsor, right? But a standard employer sponsor ultimately controls, in many respects, the fund. So it's a fairly rare event that we see with regards to standard employers. So we don't need to look at it too deeply with the whole concept under a related party. And then the last one is the Part 8 associate of members or standard employers. And that's one of those areas where we have to go, okay, well, who are these Part 8 associates? And when we look at these Part 8 associates, we drill down and say, okay, well, the members of the fund. We then have to go down another line, and that next line is the relatives of the members, and then we need to understand who relatives are. We then need to go, okay, is there anybody in a partnership, right? So if you're in a partnership, and we're talking tax partnerships here, then those partners are going to be related parties of the member, and the partners in that partnership. So that expands it further, and then spouse and children of partners in partnership. So we have to have clarity, and today's webinar is not one where I'm going to drill down too deeply on the definition of a partnership from a tax point of view, but people need to do their research to make sure what sort of investments are they held in to determine whether or not someone is in a partnership. And a very common one that is often spoken about is tenants in common. So where you've got this shared income from the rental income off a property, then you are in effect in a partnership. So you need to have clarity as to those people, if they're not related to you, are effectively related to you under the fact that they are partners in a partnership with you. And then you have these controlled companies and controlled trusts. And I'm going to come back to both of those in a moment, because they are less of an issue when we're dealing with the acquisition of an asset from a related party, unless we're acquiring something from a family trust or from another unit trust. They are more often than not an issue when we're dealing with the investments that the super fund's actually making. So when we're investing in a related company or we're investing in a related trust, then we need to understand whether or not we control that company, whether we control that trust, so whether it will be a related entity for the expanded definition and the expanded exclusions of what is an in-house asset. So relatives is a fairly comprehensive term. There are obviously a few people that don't count in the definition of relative for related party transactions under this part of the SIS Act, who would count as a relative under the definition of 17A of defining, who is and isn't an employee versus employer relationship. And so that's a whole different area, but we do have two different relative definitions contained within the SIS Act. And that's one of the crazy elements of super law, is that there's often this confusion associated with it there. So the key ones there: former spouse is not a relative, and cousins are not relatives. The former spouse one's an interesting one. Again, not so much from an acquisition of an asset's point of view, and there are exceptions from the acquisition rule with regards to relationship and marriage breakdowns anyhow. But again, the former spouse becomes more of an issue when you're talking about the actual investments that a fund's going to make. So we look at those controlled companies and those controlled trusts, and the obvious one for most people is that majority voting interest. So if the entity or entities are in a position to cast or control the casting of more than 50% of the maximum number of votes, and similarly with a trust, a member and its entities have a fixed entitlement to more than 50% of the capital income of the trust, then effectively it will be related. Now, more than 50 is clearly the key there. So somebody with 50% from a voting point of view or from a unit trust entitlement point of view is not control. However, you then have sufficient influence. And the key about sufficient influence, it talks about this rather expansive definition. If the company or a majority of its directors is accustomed or under an obligation, whether it's formal or informal, or might reasonably be expected to act in accordance with the directions, instructions, or wishes of the entity or entities, whether those directions, instructions, or wishes are or might reasonably be expected to be communicated directly or through interposed companies, partnerships, or trust, then you're influencing a company. Now that's a mouthful, right? I don't regularly read that one out because it is such a mouthful. But what it ultimately means is you don't have to control the company by shareholding. You don't even have to control the company by position held within the company to control the company, right? And you're seeing more and more references to sufficient influence being raised through various cases in time. And so it really is factual, and the tax office want to dig deep if there is any consideration or concern. So if you've got a 50-50 trust or company, people often ask, is it related? Well, the reality comes down to who has the power, right? How much power if there's two parties in there and they're not related because they're not relatives, right? Does either of them exert any specific power? And you might need to look through the constitution, you might need to look through the deed to make sure, particularly with the trust, whether they've got their power to appoint or remove the trustees, which is a key consideration to take on board. So there's all these elements that have to be considered, not only when we're looking at who we're acquiring assets from, but more importantly, when we are looking at investing in a company or investing in a trust, we need to ensure that that is not a related company or trust, unless it satisfies either A, the in-house asset requirements, which we'll touch on in a moment, or it satisfies the in-house asset exceptions, such as the division 13.3A, or otherwise known as a 13.22C trust or company. So we need to be mindful of how all those requirements operate to ensure that we don't get it wrong. And once we know who a related party is, and again, I've always been a bit of a fan of the old KISS approach, keep it simple. And if we can keep it simple, then it's a matter of going, okay, do we understand what the actual then further investment restrictions are within the fund? So yes, we've got our collectibles and personal use assets, fairly minor inconvenience in regards to the way that the legislation is written there as to what you can and can't do, but certainly something that we need to be mindful of. Restriction from the fund from lending or providing financial assistance to the members or relatives. We'll touch on that in a moment. Prohibition on the use of borrowings, except in some limited circumstances. And of course, one of those is a limited recourse borrowing arrangement. We then have, by extension, not something that I'll spend any time on today, but by extension of the LRBA requirements, we've then got our related party loan requirements, right? So if we're going to do loans with related parties, then to ensure compliance from a regulatory point of view, we have to make sure we satisfy the conditions that the Commissioner have provided for us under PCG 2016-5. Now, that's to ensure that we don't have the regulator on our back. We don't have to follow those LRBA requirements if we're benchmarking our loan against another offer that we've received from a commercial lender. But again, there's work to be done there. It's like market valuations. It's not just a guess. It's about identifying and determining that the appropriate action has been taken there. Yes, Sally's just made a point. Also, Reg 409, diversified investment strategy. Of course, the investment strategy overrides a lot of these whole related party issues as well, is to ensure that, particularly, I've always been pretty strong on, if you're going to invest in any related party investments particularly, then you want to make sure that you've got that well and truly covered off from an investment strategy point of view. One, obviously, you've got to satisfy your diversification requirements. Now, diversification doesn't mean you need to diversify. It means you need to state why you're not diversifying and what the objective of the fund is, but also the risk, the return. And again, risk is a key one when we're dealing with related party transactions, to ensure we understand the risk associated with it. And the flip side of all of that, and the last couple that I'm going to touch on there, acquiring assets from a related party, but then the restriction on the level of in-house assets, so investments in related parties. A lot of those considerations come from the facts and the reality that the regulator understands that there is interest in investing in yourself, right? So there is an interest, particularly from an SMSF point of view, and prior to self-managed funds and excluded fund, in investing in your own companies, in your own trusts that have these other investments. And they're not saying you can't do it, but they're saying, well, there's been enough evidence, there's been enough scenarios around in time that says if somebody invests in a related party, and they invest all their super in that related party, and then that related party crashes and burns, well, not only have they lost their business, they potentially also lost their retirement savings as well. And that's ultimately what they're trying to restrict. Now, if we go back and look at the collectibles and personal use asset rules, right, they were introduced because they were saying, well, people are getting too much of a current day benefit from these investments, so we want to restrict that. But the other thing they said is, how many of these investments are passion-based investments, not clear-minded investments? So they're not necessarily, or they weren't necessarily return-driven. They were effectively the passion economy. And so I love art, or I love wine, or I love whatever it might be, but it wasn't necessarily, this can provide me with quality retirement benefit. When they made those collectible and personal use asset changes, the Cooper Review also initially recommended abolishing in-house assets, right? And they looked at abolishing the acquisition of assets from related party rules. So there was a far broader response to that review as to what to do with related party transactions. And ultimately, the government of the day decided they would impose changes around collectibles and personal use assets, but they wouldn't restrict the in-house asset, or they wouldn't make changes to in-house asset, and they wouldn't make changes to the related party acquisition rules. But they did try to legislate it. They actually introduced draft legislation for that very measure. It just never proceeded. So these are the sorts of things that we need to be mindful of. So just to roll through a couple of those investment restrictions relatively quickly, and touch then on those the cases that I wanted to. The loans and financial assistance. To remember, as I said, number one compliance breach for self-managed superannuation fund. Section 65 prohibits it. Unfortunately, we also have our Section 71 definition of an in-house asset, which includes a loan to a related party. So we know on one hand, Section 65, which overrides the other section, prohibits the lending or the provision of financial assistance to a member or relative. 71 is the related entity. So again, we go back to our controlling point of view, and we can lend money to a company, we can lend money to a trust. But what is the purpose of that loan? You know, if the purpose of that loan is, I want to say of noble cause, but that's kind of a bit of a throwaway line there. If it's not because that company needs to get it, that company is in financial trouble, right? And so therefore the money is just going to be used to then ultimately assist the member in getting out of that financial strife, then you can't do it under either the in-house asset rules and obviously the loans to financial assistance to members or relatives rules. But if there is an alternative purpose for it, then certainly these loans can operate. But you need to understand that there's a lot more to financial assistance than just pure cash, with the expectation of receiving that cash back. And that's where we start to look at the purchasing of assets for more than market value, acquiring services, and this is where that whole gnarly thing comes into it that we need to be mindful of, forgiving debt, selling assets for less than market value. So all of these key issues that can come into the whole concept of financial assistance. And so we need to be clear, and one of the things that I've always done when sort of doing accreditation for SMSF professionals is just try to hone in on that whole Section 65 and identify that it is the biggest breach that we see, and it always has been the biggest breach. And so we have to be very clear with our trustees when they're saying, look, we've got access to the super fund account, can we just use this? Absolutely not. You cannot use it. And there's no circumstances where you can. And if you look at the commissioner and the way that they've approached things like early release, they're actually starting to get a lot tougher in those regards. So we need to be mindful of that. Related party acquisition, which is ultimately, the piece of legislation that we like to sort of play around with the most in regards to what transactions possible versus what's transactions not possible. We have to look at this, but not in isolation. And the case that I'm going to reference in shortly is called Merchant's case, and I'll call it Merchant's case, and that is, it was a case where Section 66 was not breached because Section 66 prohibits trustees from intentionally acquiring an asset from a related party with the following exceptions: listed securities, business real property, and certain in-house assets. Right? Well, that fund acquired listed shares. However, the reason they acquired those listed shares right, didn't satisfy the sole purpose test. So they did not breach section 66, they breached section 62. But I'll come back and touch on that in a moment. So we need to understand that when we're looking to acquire assets, any assets, the first question that we have to ask is, who are we acquiring those assets from? Right. Then once we know who we're acquiring the assets from, if it is a related party, we go through our pre-chart, say, right, well, what can I acquire from a related party? Well, I can acquire listed securities. I can acquire business real property, so I need to understand what business real property is. And you can go back, and we did a webinar on business real property earlier in the year, or might have been late last year, but we have done a business real property webinar in recent times. And we then also need to understand that there are certain in-house assets, so certain related party transactions, certain related party investments that we can also acquire. With all of these, the acquisition must be undertaken at market value. So again, there's an additional investment requirement on these transactions to ensure that it's done at market value. But one of the key issues is the in-house asset rules and how they work. And again, it's a matter of going, okay, well, the definition is fairly straightforward. It's the exceptions that create a lot of the issues, because the exceptions and then the broadening of the definition of related parties that become more of an issue. So an in-house asset includes a loan to a related party, an investment in a related party, an investment in a related trust, and an asset subject to a lease or lease arrangement between the trustees of the fund and a related party. Now, that all looks relatively clear until we know that Section 65 says, well, you can't lend money to a member or relative. Well, they're a subsection of related parties, so that already carves out part of the transaction. But then an asset subject to a lease or lease arrangement between the trustees of the fund and a related party also has carve-outs. And there's a old tax determination or interpretive decision that goes all the way back to potentially 2004. I might be stretching that, might only be 10 years old, but it goes back far enough to talk about leasing an asset to a partnership. If you lease an asset to a partnership, then you are leasing an asset to a related party that is effectively incorporates the members or relatives. So partnerships are not the related entity that a trust or a company is, and it can be problematic. So, you know, who and how you can undertake these leases is really important to understand. But then we've got our exceptions to the in-house asset rules, you know, and business real property that's leased to a related party. That is an exception to the rule. So we go, what's an in-house asset? An investment that's subject to a lease to a related party. What's an exclusion? Well, if that asset happens to be business real property, that's an exclusion. Certain limited recourse borrowing arrangement trusts. And then we've got our division 13.3a unit trusts and companies. And of course, they are the big exclusion, and they sort of create significant conversation within the industry as to if you, and that they ultimately are a non-geared ungeared unit trust and company investments. And so we need to have clarity around what they are as well from an investment point of view. But again, then if we're saying, okay, well, if something is an in-house asset versus something being an exclusion to the in-house asset rules, then those assets cannot exceed 5%. Right? We can acquire them unless the acquisition puts our existing in-house assets over 5%. So therefore, we're testing these things not only at acquisition, but we're testing them annually as well to make sure that we're not breaching the 5% rules. And that becomes quite a strain on the trustees' responsibilities. And so then we look at it and say, well, is this actually to the benefit of the fund to be investing in these types of related party investments? If we then flip that out and say, okay, well, there is exceptions to the 5% rule, right? And they are our pre-1999 investments, which there's very few of, you know, and great if you've got them. There's very few of them now. There are widely held trusts, and of course, that's quite a specific definition as well, and generally means that there's a significant number of investors over and above the number of 20 there. But then there's these Div 13.3a investments, the ungeared investments and the unit trust or companies, and those ungeared unit trust investments, they cannot invest in other entities. They can only invest in effectively non-company and non-trust based assets. So they can invest in property, as an example. If they do invest in property, you know, they can only lease business real property to related parties. So if they invest in residential property, it must be leased to non-related parties, they must transact on a commercial basis. So all transactions must be on an arm's length basis. And similarly, they cannot be doing things like carrying on a business, right? So just as a quick reference to that, and again, there's lots of cases to identify this from a tax office point of view. If you've got somebody that owns a property in a unit trust and they want to develop that property, well, the tax office will look at what their intention is to determine whether or not they're carrying on a business. And some recent cases in that regard where a couple purchased property, and within 10 days of purchasing the property, I might have the numbers wrong there, but the concept's not wrong. Within a very short time frame, they actually acquired effectively a development permit, to redevelop the existing properties, and then sell those properties off. And so even though they were individuals and they weren't property developers, the tax office deemed them to be carrying on a business. So that was revenue in nature, not capital in nature. And so if they were doing that inside the self-managed superannuation fund, they'd be carrying on a business. They're carrying on a business and that was held inside a trust, then they'd be in breach of 1322C requirements, which would mean they'd be in breach of the in-house asset, which would mean they'd have to sell the units in the unit trust. So, the in-house asset rules have all these extensions that we need to be mindful of, and that can be problematic. And so just to finish those sorts of comments off is the arm's length stuff. And I'm not going to spend any significant time, the details here in the slides for you. But from an arm's length point of view, all transactions must be made and maintained on arm's length terms. So we need to ensure that the parties don't have to be on arm's length, but that the terms of the transactions are on arm's length. And so, any nudge, wink, wink arrangements that occur in the SMSF space are going to be problematic with regards to the arm's length requirements. And again, those 1322C investments are just one of the spaces that can be problematic. Now, this whole related party gnarly stuff, I've spoken about it at great lengths over the last couple of years. And to me, the key one is, as I said, this finalisation of tax ruling 2010-1 is going to be critical because historically as an SMSF industry, we have said, if you want to transfer shares in, if you want to transfer property in, you can do it as a combination of cash, and in specie contributions, however you so choose to do it. You still can, right? But you've got to document. So before now, the documentation was almost a byproduct of it. Now the documentation has to be in place prior to. So the contract has to be pretty open and honest about the fact that the super fund is purchasing a certain portion of it, and that a certain portion of it will be purchased via the use of in specie contribution or whatever. And so just the way we document these transactions is going to change. And of course, the other thing that we're waiting on with LCR 2021-2 and the likely amendments to that is this whole capacity as which we're undertaking transactions. Are we undertaking it in our trustee capacity or our individual capacity? And again, these are all key areas that from a related party point of view, we used to always say, as an industry, well, I can undertake that work myself. Oh, well, the fund doesn't have to pay for it. That was the rules. It's not the rules now, right? So the rules now is that if you're going to undertake the work, what capacity you're doing it in. Is it based on the skills that you currently maintain and hold? Because if it's been done on that basis, right, then should you be remunerated? Then the question comes, can you be remunerated under 17B, right? And if you can be remunerated, then you've got to make sure it's at arm's length. If you can't be remunerated, then you're potentially creating a non-arm's length expenditure issue for the fund and a tax liability. So then are you better off just getting some other party to undertake the work versus can you do that work in your capacity as trustee? These are all the questions now that make these related party transactions, which have historically not been so significant, it makes them far more significant. So what I want to do for the last 10 minutes is run through a couple of cases and then just finish off with a bit of a summary, as I said before. Now, a couple of these cases I've spoken about before for different purposes, but I just wanted to touch on them with reference to how they fit in with regards to related party transactions. So this WZWK one was a classic example. This person, this individual, was the sole director, corporate trustee. They were a registered tax agent. They were an approved SMSF auditor, and they were a chartered accountant. So In theory, they had the capacity to know what they were doing. If you read the court case, it's a fun little read, but if you read the court case, they are pretty adamant that what they were doing was fine. But the commissioner kind of felt otherwise. So there was a number of issues here. There was one to do with drawing down benefits under the guise of a complying pension, right? So under termination of employment, so there's a condition of release thing. Not going to focus on that today. That was a great breach of legislation in its own right, drawing down $800,000 when you're 47 years of age. But in addition to that, the key issue was that they had a self-managed super fund, set up another self-managed super fund, then transferred assets from one fund to the other. And so in doing that, they created a number of key issues associated with the acquisition of asset from related party rules, but also things like market valuation requirements around acquiring assets and ensuring that the valuations were appropriate. And really what came into question here was the trustee, in addition to one, assuming that they could draw out $800,000 worth of benefits under this complying pension concept for terminating gainful employment. But the other thing was that they did their own asset valuation because they were an accountant, because they had experience in superannuation, and they felt that they could do the appropriate valuation. However, their explanation to the commissioner was a little bit, well, not to the commissioner, to the courts, was a little bit poor in the sense that, you know, these trusts, or this unit trust A had all these intellectual property style investments in it. So again, where does that sit in the definition of 13.3A? That's a real interesting one that I haven't really had time to contemplate. But to think other than, okay, you know, it's not an investment in another entity, it's not an investment in another trust. So potentially there's an issue there. However, the intellectual property then resulted in licensing fees, and so, you know, potentially they were carrying on a business in some way, shape, or form. But it was really complex in that regard, other than to say that the valuation he put on these investments, sort of when it all came crumbling down, was that because the licensing agreements could be terminated, he said that they had no value, despite the fact that they were generating hundreds of thousands of dollars worth of income. And so the commissioner ultimately said, well, you know, your whole valuation issue is a bit of a ruse, because you're basically just having this income going into the fund, you're valuing it higher to be able to then calculate a higher amount of income to draw down from a pension point of view, and then you're devaluing those investments to then ultimately wind up the superannuation fund. So one, there was the whole issue associated with whether or not the investments could be acquired from a related party, right? So 66 breach. Two, there was what was the purpose of all these transactions, and there was really no undertaking from a core purpose point of view. There was actually no reason why this second fund should have been set up, other than to create this dodgy scheme to access the super under the termination of employment strategy. So, whole lot of issues with it. Ultimately, got a few $1 million worth of fines or tax liability and penalties, and was disqualified as being the trustee of a fund. Pretty significant one. Merchant, as I said before, significant from an industry point of view, because Gordon Merchant ultimately didn't do anything that the legislation didn't say he could do. I think I said that right. But he acquired, and he was a co-founder of Billabong, and he acquired Billabong shares in his self-managed super fund from his family trust. The issue was that those Billabong shares were sold at a significant loss by the family trust, right, which was helpful in offsetting effectively a $85 million gain in the fund, in the family trust, that was based on this other investment that he owns. So the transfer, whilst legal in the sense of Section 66 provides for it, the tax officer said, well, you've actually breached the sole purpose test, and you've breached Section 65, because the whole objective was to transfer these shares to write off the tax liability inside the family trust, which then means that the distribution from the family trust is less tax for him individually. And so it was considered to be a breach of 65, of 62, but not of Section 66 from an acquisition point of view. And interestingly, he was disqualified by the commissioner, but appealed that, and then that appeal was upheld in the sense that they said, well, he doesn't pose a threat. He's just done this one transaction. Whilst it's significant in value, he's only undertaken this one transaction, as opposed to some of these others that undertook multiple transactions. But his decision was based on advice that he'd received, and that was that Section 66 said you can acquire these assets from a related party. And so ultimately he was put under some conditions to remain as trustee of his fund, but was ultimately determined not a fit and proper person. So he's, in theory, still the trustee of the fund. So, again, when you look at the differences between that and the other one, can be significant. And then when you look at the differences between Merchant and Coronica versus Commissioner of Tax, and Coronica has been going on since 2021, and has recently just been appealed again. So in Coronica, there was an acquisition of assets from a related party. Again, was a CPA for 50 years, had undertaken asset valuations for insolvencies to do with Timber Corp and other things. And so, had a reputable standing with regards to a number of the transactions. However, what Mr. Coronica did in this instance was, the tax office said that it was something like 45 breaches of the legislation. Well, that's 2021 case says that. Later on, that number seems to have shrunk a little bit. So I suspect that a few of the transactions have been set aside as not being as problematic. But ultimately provided a valuation because he purchased some shares in his company. So he owned 100 shares in his own company, and he then transferred those 100 shares to the self-managed super fund. And the valuation, so his fund was valued at roughly $2 million. There was no question about that. That was all genuinely legitimate. But then the investment in his company, which had a whole heap of retained profits sitting within them, he had done some stuff to do with the valuations to bring the valuation of that property down to about 100,000, which then put it comfortably at the 5% mark, as opposed to the valuation that the ATO deemed appropriate, which was about 220,000, which put it at whatever it was about 9.4%. And so in that instance, the breach was really linked to, well, there was two, because the asset couldn't have been acquired in the first place. So there was an acquisition of an asset issue there. There was a whole lot of nuances around whether the asset satisfied the definition of 1322C. It clearly didn't, but the accountant was adamant that he did, because he decided that the law was interpreted differently to everybody else, right? So, and he was very adamant that his interpretation was the correct one. And still, through the 4 appeals that this case has gone through, still adamant that he hasn't done anything wrong. But if you actually read through the facts, it's clear that there are a lot of things that's done wrong. And the last appeal, the final appeal, was he's come out and said, well, hang on, you've just let Merchant off, right? You've let him off and let him remain as trustee of the fund. And so his disqualification has been reversed. So my facts are the same, reverse my disqualification. And the commissioner and the courts have said, actually, your case is a lot worse. You did it on multiple events, not just one event. And you should have known better because of your profession. And so therefore your disqualification stays. So again, key issues there. And then that BPFN one is, again, it's another situation where multiple entities were put in place to do some related party loans. And then those related party loans resulted in unrelated loans. And ultimately it was deemed to, one, not be an in-house asset issue and not be a non-arm's length investment issue. But the tax office have basically come out with a decision impact statement and said, just be mindful of what you're trying to do and don't try and be too cute, is really a summary of their decision impact statement. So as we wind this up, what can go wrong? What can the penalties be? Well, we obviously can be put under enforceable undertakings, where we go to the ATO and say, this is how we're going to fix it, and they might accept that. And some of these cases have gone through that and failed to do it. Otherwise, it could be a rectification direction. So the ATO might put down a path forward for trustees to follow. Some of these, many of these, are subject to administration penalties, disqualification. We've seen that there. And then there are other types of penalties that can be imposed. And we know that those penalties are fairly significant for loans. We know they're significant for borrowings and in-house asset. And they're less significant for a couple of the other standards as well. But when we look at these penalties, you know, the ultimate result can be that when we're talking about things like civil and criminal penalties, like if you acquire an asset, and I haven't seen this, right, but if you acquire an asset from a related party that you can't have done, then the penalty can be imprisonment, right? Sole purpose test, lending, those sorts of ones, they're all going to be linked primarily to financial penalties and disqualification, whereas the acquisition stuff could ultimately result in imprisonment in a worst case scenario. So just be mindful of how those rules work. So as I said, I wanted to summarize it by basically asking a couple of questions there, and there's ultimately three, but the first one is, who are the parties to the transaction? So if we know who the parties to the transaction are, then we can then determine what we need to do. We can determine, okay, we have to be a lot cleaner with regards to our arm's length requirements, not that they don't apply beyond that, but we definitely in related party transaction sense need to make sure that we follow the requirements there. The next question always is, okay, well, if it's a related party, then where do we fit with regards to the acquisition rules? So can we acquire this investment from a related party? All right, so the first question is who, the second question is what, and then the third test is going to be how much. So if it's listed securities, there is no restriction. If it's business rule property, there is no restrictions. If it's an in-house asset, then the maximum is going to be that 5% limit. If it's an exclusion to the in-house asset, then there's no restriction. So it's always the who are we dealing with, what are we dealing with, and then how much are we dealing with in that order. And if you get those orders right, then you're going to have a far lot less problems with regards to related party transactions. So that's it. Thank you for attending today's. We've got 4 more webinars for the year, and glad that the comment that I received today was around the investment strategy, because investment strategies on the back of this related party stuff, but also as we lead into the October session, we're going to talk about investment strategies next up, then segregating assets and the beneficiaries of exempt current pension income. But then also following that up, I'm going to talk about commencing and ceasing a pension, which is not a new concept, but we've had finalisation of a ruling from 2013, which will have significance, particularly around transfer balance cap, around segregation, but also around that ECPI deduction as well. So those sort of 3 subjects sit nicely together. And then we'll wind up the year in December. We'll do a bit of a review of the year with a number of the concepts that have impacted self-managed super funds for the year. So thank you for attending. As always, you will receive your CPD and a copy of the presentation. And I look forward to seeing you all, or having you all online with me for the September webinar on the 17th of September. Thanks a lot. We'll see you later.